Good evening. Happy Thursday, round whatever. We're going to go over the Decastro versus Abrams et al. Filing from today. This is docket number 86 and 87. I say that even though this says 86, Chile forgot to split out his memorandum of points and authorities, so the clerk did it for him, but I'm too lazy to get 86 and 87, the corrected 86 and the corrected 87, so we're just going to go with this one, and you'll just have to use your imagination. It's imagination time. Close your eyes and imagine. So this is Chile's motion to dismiss Joshua Abrams' counterclaim. Pursuant to Federal Rule of Civil Procedure 12B, that's objections, how to present defenses. So you can assert these defenses by motion. Woohoo. So Chile moves the court for an order dismissing the counterclaim filed by Abrams. He hasn't done one for Peter yet, but he's trying to dismiss Abrams' counterclaim. And he's doing it for lack of subject matter jurisdiction, lack of personal jurisdiction, insufficient process, and failure to state a claim. I think this, if he is going to win, this is what he's going to win on. He's not going to win on personal jurisdiction. He's not going to win on process, and he's not going to win on failure to state a claim. My opinion, your mileage may vary. So then we got the memorandum of law. Plaintiff submits this memorandum of law in support of its motion to dismiss the counterclaim filed by Abrams. A. Lack of subject matter jurisdiction. Federal Rules of Civil Procedure 12B1. He says the counterclaim is compulsory, or is not compulsory, it's permissive, as it does not rise out of the transactions or occurrence that is the subject of the plaintiff's complaint. Well, now, that's an interesting question, and it's an interesting question because the counterclaim arose as a response to the first amended, his initial complaint, which was for defamation and intentional infliction of emotional distress. So when it was claimed, those existed. And I think because that existed, there is a good argument to make that it's still valid. For example, if the defamation claim from Chile existed until both of them got further into it, and then Abrams did a motion for summary judgment on Chile's defamation claim, and it went away, then Abrams' defamation claim wouldn't necessarily go away, even though Chile's defamation claim had gone away, because it was there at one time, and it might be arising out of the same transactions or occurrences. And he's citing to Federal Rule of Civil Procedure 13A. 13A is compulsory counterclaim. And there's also permissive counterclaims. And this was last updated December of 2009. That's when the last update was. Keep that in mind. So compulsory counterclaim in general, blah, blah, blah. Permissive counterclaim. A pleading may state as a counterclaim against an opposing party any claim that's not compulsory. It says it may state it. It may state it. It says a pleading may state as a counterclaim against an opposing party any claim that's not compulsory. It may state it. It's not must, it may. So, I don't know why he's citing that particularly, but okay. Counterclaim is not a part of the same case or controversy and therefore requires an independent basis for jurisdiction. Well, it was, and then you voluntarily basically dismissed your defamation. So I don't know about that. And he cites Globe Naps versus Verizon New Eng Inc. And and they found that supplemental jurisdiction exists over counterclaims, over all compulsory and most permissive counterclaims. So, okay, I don't know why you're thinking this says something different. We hold that Section 1367, that's 28 U.S.C. 1367, supersedes case law and supplemental jurisdiction that is distinguished between compulsory and permissive counterclaims. The statute's plain text does not distinguish or limit jurisdiction over counterclaims, although it imposes other limits. And as the Supreme Court observed, nothing in Section 1367 indicates a congressional intent to recognize, preserve, or create some meaningful substantive distinction between the jurisdictional categories we have historically labeled pendant and ancillary, which is basically saying compulsory and permissive. Thus, 1367 abolishes the conceptual framework underpinning the old compulsory permissive counterclaim distinction. This is from 2010. So, I don't know. Even if counterclaim was found to be supplemental jurisdiction, its state claims would substantially dominate over the original federal claims and would raise the expense of seeking resolution and should not be allowed. This is not really a good argument. It's kind of a throwaway argument. Counterclaim contains only state claims, does not establish a state that has jurisdiction over plaintiff. Plaintiff demands to be sued under California state law and not federal law as to maintain substantive rights under that state. So, because you're in Massachusetts, you're in court in Massachusetts, you would use Massachusetts choice of law. And so, I believe Massachusetts choice of law for this particular counterclaim, I believe it chooses Massachusetts law. Now, your Chili's original defamation under Massachusetts choice of law would have used California substantive law for the defamation, because the plaintiff, the person who was injured by the defamation, was in California, and so they'd use California law. That's what Massachusetts does. If Josh Abrams is the injured party, my understanding of Massachusetts choice of law would be that it would use Massachusetts law. And you can't just demand to be sued under California law. I mean, according to Abrams, allegedly you defamed someone in Massachusetts. So you're subject to that law. Just like when he allegedly defamed someone in California, he became subject to California law. Counterclaim fails to establish diversity jurisdiction. Now this is where I think he has some merit to it. Now, just because, the factual allegations in prayer for relief do not meet the statutory minimum for a diversity case. So by itself, yes, Josh's counterclaim could not stand, because in order to be in federal court, if there's no federal question, you have to have diversity jurisdiction. And that means that the plaintiffs have to be residents of different states than the defendants. And there has to be over $75,000 in controversy. And while Josh states it, just because he stated it was more than $75,000 doesn't mean it is. And the court could very easily say, look, there's not $75,000 there. He said he would also challenge the amounts claimed and demand the damages be quantified and submitted with proof. I don't think it's going to get to that point. I don't think that's a thing that the court's going to allow. I think that the court might decline to retain jurisdiction over the defamation case, since we're now in a the court might hang on to it simply because Chili amends his complaint all the time, and he might try to bring back the defamation. But see, I don't even know if Josh is a defendant at this point, to be perfectly honest with you. This is so messy. because Josh could just file a motion to be dismissed as a defendant. That's what that's what one group of people did in the Ironton case. They're like, you amended your complaint and you didn't include any allegations against us, so we're filing a motion basically to be dismissed. I think it was a 12B5. It was a 12B5. Or maybe it was a 12B6, failure to state a claim. Yeah, it was something like that. I don't remember exactly what it was, but Chile forgot to include any allegations against them in his amended complaint. And so that's how they got dismissed from it. Because there you go. Anyway. So if Josh is no longer a party, if he files a motion to dismiss the claim as far as he's concerned, and the court grants it, then I'm sure the court would let the counterclaim go too. Because the court doesn't want to hang on to that. It's a garbage claim. I'm sure the court realizes it's a garbage claim, and it's not related to anything that they're going to be dealing with here and now. So if he's going to win, I think he's going to win in this part, lack of subject matter jurisdiction. His next area is lack of personal jurisdiction. So subject matter jurisdiction means the court can hear the case. Personal jurisdiction means the court has power over you. And one problem for Chile is that when he walked into or otherwise availed himself of the district court in Massachusetts, he voluntarily gave the district court of Massachusetts personal jurisdiction over him in this case or controversy. And then when he served Josh Abrams the summons and the complaint, that gave the district court of Massachusetts personal jurisdiction over Josh Abrams. So now they're both in front of the court and subject to it. He says, at the time service of process occurred for this counterclaim, I was not a resident of Massachusetts, nor physically present in the state, nor have I availed myself of the protections of California. See, I don't know why he says he hasn't availed himself of the protections of California. He gave the court jurisdiction when he filed his complaint in Massachusetts District Court. He says, additionally, Abrams has not offered any alleged facts to establish personal jurisdiction by the court and bears a burden to do so. No, you filed the complaint there, dude. That's how the court has jurisdiction over you. Sorry. Insufficient process. Process is the paperwork. It's the summons and the complaint. So if insufficient process means like maybe you got served a summons but you didn't get served a complaint, or maybe there was an error on the summons or something like that, that would be insufficient process. As with a complaint, a counterclaim must contain a short and plain statement of the grounds for the court's jurisdiction, unless the court already has jurisdiction and the claim needs no new jurisdictional support. That sounds like he's talking about subject matter jurisdiction there. FRCP 8. General Rules of Pleadings. 8, what did he say? A1? 8A1. A pleading that states a claim relief must contain a short and plain statement of the grounds for the court's jurisdiction. This is subject matter jurisdiction. Unless the court already has subject matter jurisdiction, the claim needs no new jurisdictional support. See, he's talking about the claim. The claim needs no new jurisdictional support. So this has nothing to do with process. In a permissive counterclaim, a court does not already have jurisdiction, and the counterclaim contains no statement once conclusory statements are filtered out. A lot of the statements that you're going to make in a complaint in federal court. Federal courts aren't fact-based pleadings. They're notice-based pleadings. So you can make a lot of conclusory statements. I mean, conclusory statements aren't great for dealing with a 12B6 or a motion for summary judgment or judgment on the pleadings, but they're sufficient to put you on notice. But I don't know what this has to do with insufficient process. This again has nothing to do with insufficient process. Local Rule 40.1G5 notice requires a notice of related case be filed. The counterclaim is missing such notice. So it's designation of relatedness. So what this is talking about is if there is another case that's already been filed that's dealing with the same or related subject matter. So say, for example, Bob is suing Charlie for defective products that Charlie was producing. And Debbie files a lawsuit against Charlie. Then Charlie might file a notice, a designation of relatedness, saying that these are the same issues and same facts and same it's related. So we need to do these together. That kind of thing. That's what we're looking at. Or where let's say someone sues like the driver of an automobile over harm from a traffic accident, and then he also sues his insurance carrier, his own insurance carrier, for failing to pay out underinsured motorist coverage. Well, then those two are related cases because they're both dealing with the harm from the automobile accident. And so you'd file a designation of relatedness. If you're filing a counterclaim, you don't have to file one of those because it's the same case. You're filing it in the same case. There's not a related case. It is the same case. You're filing a counterclaim in the same case. Then he says, failure to state a claim. Counterclaim makes no claim other than defamation. It did. It stated certain things that Chili was saying about Abrams being like, what was it? A dangerous criminal or something like that. It made claims about defamation. It said certain statements that Chili made were defamatory. There's no federal defamation cause of action. I know, it's a state cause of action. That's why you were talking about the supplemental jurisdiction previously. If the defamation is under a state, no state authority is listed that would allow one to plead the necessary elements, and so the pleading fails to do so. If the defamation is under a state, no state authority is listed that would allow one to plead the necessary elements, and so the pleading fails to do so. I think he's talking about there's no statute, no state statute cited, but a lot of times defamation is common law. It's just from various statutes, or not statutes, from case law. Under Federal Rule of Civil Procedure 8A2, a pleading must contain a short and plain statement of the claim showing the pleader is entitled to relief. Yeah. You defame Josh, and so he's entitled to relief. Counterclaim has a prayer for a relief section, but cites no authority that entitles any relief, so fails to state a claim upon which relief can be granted. You don't have to cite authorities in your complaint, so that's stupid. For the foregoing reasons, plaintiff requests this court enter an order dismissing all claims in the counterclaim pursuant to Federal Rules of Civil Procedure 12B in their entirety. So again, I think the court really would want to get rid of it. And if the court is going to get rid of it, I think the court would get rid of it for lack of jurisdiction. But there is a reasonable argument still that the court has jurisdiction over it. So anyway, there you go. Thanks for watching. Have a great day.